Hi, I'm Art Marapees, Chair of the Employee Benefits Group at Barclay Damon. I'm joined by Alexandra Lugo, Lexi, a fellow ERISA lawyer and valued member of our group. In addition to myself and Lexi, our group includes Ray McCabe, a tax and benefits attorney with experience working for the Chief Counsel's Office of the IRS, and Cheryl Vandenhandel, a paralegal with substantial experience in the 401k plan administrative area. We want to thank you for the opportunity to highlight the employee benefit plan services we offer professional practices, services tailored to the specific needs of professional practices. I'll start by outlining the retirement plan services we offer and then turn to Lexi for any general comments she may have, and specifically for a summary of employee benefit plan services we can offer in connection with medical and other health and welfare benefit programs. Turning now to qualified plan services. All professional practices want to maximize contributions and other benefits for owners and key employees while providing competitive benefits for all others. The owners of a professional practice spend a good deal of money on employees and need to ensure they're maximizing their own. We can help you find the best retirement plan solution given these objectives. Second point, a service that we can offer in the compliance realm. First was plan design. Are you doing the best you can do for yourself while still providing competitive benefits for your employees? A critically important component of retirement plan management is the need to ensure that beneficiary designations that are filed by plan participants are consistent with the terms of the plan and are kept up to date. Professionals accumulate substantial amounts of money in their retirement accounts over the course of a career. And like a will, they need to be sure that those beneficiary designations reflect their intent and are enforceable on death. I think probably most of you know that spouses have rights under federal law with respect to death benefits. Those rights need to be protected. Failing to do so could invalidate a beneficiary designation or at the very least lead to costly litigation over the entitlement to proceeds. Likewise, failing to update a beneficiary designation for life events, such as, for example, remarriage, can lead to costly disputes between, for example, children of a prior marriage and a current spouse. Beneficiary designations should not be trusted, in our view, to retirement plan investment advisors or record keepers, but to experienced ERISA attorneys. We do a fair amount of this and can help you with that. Another compliance issue that professional practices need to be keenly aware of is that professionals need to understand, we're lawyers in the same situation, that our personal assets are protected to the maximum extent possible from claims by employees, former employees, and their surviving spouses and other beneficiaries. Under federal law, the owners of most professional practices are personally liable to participants for investment losses and other losses caused by faulty administration of a plan. Meeting fiduciary responsibilities to minimize the risk of litigation liability is something we routinely help professionals do in connection with their plans. This includes, most importantly, making sure that the firms that you've hired to run your plans are qualified and experienced. And if something does go wrong, you need to be sure that your personal assets are protected, that your TPAs, record keepers, investment advisors are willing and able to indemnify you through their service agreements, in the event of losses caused by their mistakes. We also suggest that professionals, all qualified plan fiduciaries really, have fiduciary liability insurance protection for themselves and for the plan. Again, to ensure that to the extent something goes wrong, you have maximum protection. We are also seeing cybersecurity issues arise more and more in connection with online record-keeping services. There is cybersecurity insurance that should be investigated as well, and we can help you do that through our cybersecurity insurance team. Finally, qualified retirement plans are subject to a number of complicated rules under the Internal Revenue Code that can be very costly from a tax standpoint. We can do a review of your plan to ensure that your plan is being operated in accordance with those rules. And if we find a problem, we can help you correct it through voluntary IRS correction programs for a fee that would be substantially less expensive than the fee that would be paid if the IRS discovers this problem on audit. So just in a sum, what I've highlighted for you are 4 different types of services we provide for professional practices. One is a plan design service that reviews your plan to determine if you're maximizing your benefits while still providing competitive benefits for your employees. The other 3 are really important compliance issues that we encounter in our practice with professionals on a routine basis. So I'd like to turn now to Lexi for a discussion, any of the things that I've just mentioned, but in particular to talk about the employee benefit plan services we offer in connection with medical plans and other health and welfare benefit plans. Thank you. Lexi?
Thank you, Art. Yes, as Art notes, in the qualified retirement plan space, there are a number of compliance issues that really we are best suited to assist with. In many cases, relying too heavily on vendors can lead an employer astray. And I want to touch on 2 areas in the health and welfare space that we time and again see compliance issues arising for employers. The first one is COBRA. COBRA is a federal law that requires continuation of health coverage following a loss of active coverage. Common examples are termination of employment, reduction in hours. Some things along that nature employers might have experienced this year due to COVID are furloughs, temporary layoffs, sometimes culminating in a rehire or reduced work schedules. When an employee has a COBRA event, they must be provided with a COBRA notice. In our experience, many employers rely on third-party vendors to provide these notices, and these notices can be inefficient both under law and under best practices. There have been a number of COVID-related changes this year under federal law that must be communicated to employees. And we're seeing, unfortunately, that a number of vendors are not communicating these changes. We can review your vendor notices and address any issues, any deficiencies, and get you in line with what's required under law and best practices. Something employers need to be aware of is that COBRA is an obligation that falls on the employer. And typically, a third-party COBRA provider will not agree to accept any liability for deficient COBRA notices. Second, reporting of medical coverage under the Affordable Care Act. The Affordable Care Act applies to all employers who have 50 or more full-time and full-time equivalent employees. Not only do employers have to offer medical coverage, but they have to report such coverage to the IRS. Similar to COBRA, many employers outsource their ACA reporting to third-party vendors. Likewise, just like in the COBRA space, the agreements with these vendors typically have the vendor disclaiming any liability for the content of these notices. And Art and I frequently review IRS penalty assessments that were in fact triggered by vendor notices. Very commonly, these vendors will include incorrect coding, not use more protective coding that can insulate an employer from penalties. So a service we can offer is to review a sample of your ACA vendor notices for this year, make sure that they're reporting any COVID-related changes, nuances with your workforce, and make sure you are not being exposed to penalty risk. And we'd be happy to speak with you on an ongoing basis or do a consultation if you'd like to discuss any of the issues we've raised today.
Yeah, thanks, Lexi. And I want to reiterate that point that you can call us at any time to discuss any subject that we've referenced today, during this this brief discussion of what we do for professional practices without obligation. And if we feel we can help you and you agree, then we can go from there. Again, thanks for the opportunity to tell you about what it is we can do for you.